Beehive Honey Hole versus Rockin Roofing Systems. Mr. Powell, you have 3 minutes reserved.
Yes, thank you. Are these bottled waters for?
Yes,
They are.
they are. Please.
Thank you. I've been eyeing them.
Just
So let me have one of them.
Absolutely.
Yes, please do.
Thank you very much.
Yeah, you can take
Parts
one
of
too.
them are partially used.
I noticed.
The grab was.
That's not a good thing.
Oh, they are? Some of them have already been opened in there? Okay, well,
This one, that's fine.
okay.
All right, thank you.
See, is that gross?
Gross.
It's gross. It is gross. Okay.
Good.
Okay.
So may it please the court, as we've alleged in our petition and in our brief, this is a case about concealment and silence that should, by the defendant's insurance company and representative, which should not have resulted in the dismissal of our petition for failure to state a claim. Instead, the rules on notice pleading and 2 Kansas Supreme Court cases and some others should have allowed us to engage in discovery to show how the doctrine of equitable estoppel applies to bar the defendant's statute of limitations defense. We had this roofing collapse. We filed suit within 3 years under the COVID rules. It was more than 3 calendar years, but it was within timely. There's no dispute about that. And immediately at the end of March, and so I had April, May, and June to try to get Mr. Diaz served. And we attempted to serve him, tried certified mail. We sent the letter to his contacted his insurance company, sent them emails, asked for the address, and never got it. And so we're running into the 90-day deadline and then the 120-day deadline. So we issued a subpoena and they objected to the subpoena. And so the 120 days expired and we didn't.
So was there a hearing set on the objection to the subpoena?
No, there wasn't. Their objection was, well, you don't have a case going because you don't have service on the defendant. And so I made the decision, well, if the doctrine of equitable estoppel applies as a defense to bar the statute of limitations defense, then it bars it whether it's in this suit or the next suit. So we refiled the suit and we got his address from the co-defendant's files and were able to get him served. So he was served. And then they filed a motion to dismiss the petition on the statute of limitations defense. And we said, but the doctrine of equitable estoppel should toll the statute of limitations. It didn't matter if it was the first suit or second suit or when. Once there's tolling, there's tolling.
And is your argument that Shelter Insurance Company had a duty to tell you how to contact their claimant?
I'm arguing that
Isn't that kind
had
of
a-
key or
they had a duty to speak when it or not remain silent. When the subpoena was issued, they had a duty. Before
and they
that,
met that duty by responding that, and there was never a hearing on that then? Wouldn't that be what you would do then? They would say, no, we're not gonna comply with the subpoena, so you would bring them into court to hash that out, right?
Well, I looked at their objection. They said, you don't have a suit on file because there's no service, so you can't do this. And I thought, well, I'll get service, we'll find him. So I made that decision so we would have a hearing, and then we got service. So that became a moot issue.
And what was this argument in here? And I didn't bring my other notes, but that the 90 days had lapsed, that there was a lapse in the time before you requested additional time to
Well,
serve.
we felt that the request was timely within the end of the 90-day period, the way I counted it.
Okay.
They say we were a day late, but the district judge did issue the subpoena. And so the subpoena was issued, and that, don't believe that was the defense at the time to the subpoena.
Okay.
As what's important here is the rules on pleading in petitions. We got the Zimmerman case that says when a district court has granted a motion to dismiss An appellate court must accept the facts alleged as true, along with any inferences reasonably to be drawn. The appellate court then decides if those facts and inferences state a claim based on the plaintiff's theory or any other possible theory. This is really broad, favoring plaintiffs. And then we have the Journal broadcast case by the Kansas Supreme Court in 2017 that said courts must resolve every factual dispute in the plaintiff's favor. So what happened here, though, is the district judge said, well, you didn't allege that the defendant participated in this concealment or silence. Well, where is that written in the law that I have to allege that in an initial petition? KSA 6208 says notice pleading. The notice was in the pleading. Doctrine of equitable tolling applies. That was stated in there. Do I have to go through every element in a petition in order to survive a motion to dismiss with all factual details? No, not according to notice pleading. So it seems to me, with all due respect to the district court, they took the summary judgment standard, which is a failure to prove evidence on an essential point or essential element is fatal to a party's claim, and summary judgment may be granted due to the absence of evidence on an essential element. That's evidence. This was allegations. She said, well, you didn't allege this. Well, we alleged the doctrine of equitable tolling, and that should be sufficient. And so the elements were there, and in that national in the heading. Now, what's important here is even taking the judge's, and I didn't see a case cited by the district court, but even taking that rule that she said, well, you should have alleged that the defendant himself participated in it. Well, we had no chance of discovery to do that. And I think the truth slipped out on page 11 of the defendant's brief. It says, even if discovery would have revealed that Diaz instructed Shelter not to provide his address to Beehive's counsel, what would that change? Page 11, that would meet the district judge's standard that she put on us, but we never found that. Insurance company.
Do you think that is an element for this equitable estoppel claim to save the?
No, I don't. Under agency rules, there's one of the cases cited in the briefs talks about all the different types of agents we have under Kansas law, agency relationships, apparent authority, ostensible authority, implied authority. And with insureds and insurance companies, they have a contract, and the insurance company has a contractual right to defend their insured and a right to engage in settlement and a right to all sorts of rights.
Do they have an obligation, though, to help you with service on the insured?
I think they have a duty to speak when their silence is for their benefit. You see that? We had this $100,000 case. We just need good faith. Where does your insured live? We have not been able to find him. Oh, we're not going to tell you, and it's to their economic benefit. That does not seem good faith to me. It's not good faith. It's concealment of a material fact that stopped us from a timely suit. And if discovery shows what they say on page 11 of their brief, that they did that because they asked their insured, plaintiff's counsel wants to know your address. Will you provide it? And he said no, then he has participated in that
I don't think he's saying in his brief that happened. He's
No.
saying if worst case scenario,
Right.
if this fact existed, it still wouldn't make a difference. Yeah.
Well, and it would.
I mean, that's his argument.
Yes, it would make a difference. And I'd like to see those claim notes and emails and phone logs to see if that's true. But as the Judge Hurst asked, that shouldn't be the end of our case again. That should be and still argument under the policy that they had the right to speak on his behalf. So when you have a right to speak on their behalf and you conceal a simple thing like an address to your own economic benefit, that's not good faith. That's concealment, and that's what the doctrine of equitable estoppel is all about. And so another important part of our case is this, well, they cite in their brief this Farrell case, which actually cuts in favor of the plaintiff, where in Farrell, they said, I think it's on page 13 of their brief, the mere fact of remaining silent when possessing material knowledge not held by another is sufficient to toll the statute where the silence causes another to take time and action that they would not have taken. Here we attempted service at the wrong place, the wrong address. We would have gotten service at the right address in Arkansas, I believe it was. We finally found out from the co-defendant. So that case cuts our way. Another important point is the second argument in our brief about questions of fact. An agency relationship is a question of fact, according to this Barber Oil case in 1992, and it was cited again in 2014 by the Supreme Court in a case called, it's not coming to mind, but in that case, the same rule where the existence of agency is disputed. We say they're an agent, they say he wasn't. That's what we have here.
Question.
Its existence is a question of fact for the jury to be determined on proper instructions. But we don't even get there if we can't get the documents, the insurance policy, the claim logs, the emails, the payments. I'm sure they had the address. Did they contact him? Did they refuse to cooperate because the insured told him to remain silent? All of these factors are things for normal discovery that we didn't have a chance to do. So we just ask the court to reverse and let us engage in discovery and see what we can find.
Thank you very much.
Thank you. I'm gonna take my water with
Yeah, don't put it
Yes,
back in there.
yeah, don't put it back in there. That would be gross.
I don't know if
Okay,
it is.
Mr. Kohler.
Oh, sorry.
That's okay, that's okay. Morning, may it please the court. Beehive's arguments at both the motion to dismiss and on appeal in their briefing in today suffer from two fatal flaws that can't be fixed, even if they're given the opportunity to do the discovery that Mr. Powell is asking for today.
Mhm.
First, as you alluded to, Judge Arnoldberger earlier, Beehive has not at any stage pointed to any law that creates a duty for an individual or an insurance company to provide a plaintiff with an address at which that individual can be served. And I know there was some discussion about, well, the subpoena creates the duty. I think in their briefing and at the motion to dismiss, it seems like there's two buckets. There's one where they're talking about the emails back and forth before the subpoena was issued. And then they're talking about after the subpoena was issued. And I think I'll go into both of those and why neither of those apply. But the other fatal flaw that they cannot get around that we raise in our brief is that this is not a contract case. This is a negligence case. There's no privity of contract between my client and Beehive. And what that means is that the lawsuit was barred by the statute of limitations 8 months before it was ever filed. And so we don't even have to get into any questions of equitable estoppel, any questions of the calculations of the 90-day rule and relating back. This was already barred. This was, as Mr. Powell alluded to, this is a case where the allegation is that my client, who's a subcontractor, piled roofing materials on a roof in a manner that caused the roof to collapse. There's no allegation that there's any privity of contract between my client and Mr. Powell's client. that is a negligence claim, and a negligence claim has a 2-year statute of limitations.
So
And
your argument is he changed it to a contract claim in order to get within the,
yeah, so I don't know why, but
I mean,
but yes,
it shape shifted from a
yes.
negligence to a contract.
And it was never made it was never stated as a negligence claim, because by the time it was filed, it was already barred by 8 months. My point is there's no contract claim here. It is
Okay. Was it dismissed because there's no contract claim?
it was not, Your Honor.
Then that's not a question before us.
I believe, Your Honor, and we cite a case for this grounds, the Rose via Christie Health Systems in our brief, that you can affirm on other grounds, right? Like a right decision, wrong read. Yep, exactly.
Right.
Um,
But in order to determine that there was no privity of contract, there'd have to be a contract in front of a judge, et cetera, which is a hard thing to do on a dismissal.
sure, there is no allegation that I think both in fact there was no contract, but also there is no allegation in any of the 3 petitions that there was a contract between these 2 parties. So if the judge on a motion to dismiss is going to look at the facts in the petition and see there is no allegation that there is a contract between these 2 parties, look at the facts.
To dismiss allege that?
No, it did not. We did not raise that.
Really?
And I think, Your Honor, there's a Kansas Court of Appeals opinion on that ground that it's State v. White, 51 Can-App 2D 1121, that discusses an exception to the general rule that a party cannot raise an issue on appeal that wasn't raised in the district court.
There's lots of, there are
Yeah.
definitely exceptions.
But I think we fall into one of those exceptions. There's no question of, the one in the State v. White case, it involves only a question of law arising on proved or admitted facts that is determined on the issue of appeal. I think that applies here.
And did you raise that in your brief?
I did not cite the State v. White. I did not.
But I mean, did you say this is the first time on appeal and this is the exception we're relying on?
No, we did not.
Thank you.
We cited the Rose via Christie, but not that issue. So, even if we're looking at a 3-year statute of limitations, or treating the claim as this, at least for today's purposes, then they still have the duty problem, Your Honor. And so for the first bucket, if they're talking about Shelter had a duty, when Mr. Powell was emailing them asking, Shelter had a duty to respond. Where is the law that says an insurance company has a duty to respond, or even is allowed to respond on behalf of their insured and provide their insurance address for purposes of being served? And even if we were to concede, and I don't concede, but for purposes of these discussions, just speaking as if there is an agency relationship, and there's an agency relationship so close that we can treat my client as Shelter for purposes of those conversations. I don't concede that, to be clear for the record, but even if that were the case, if Mr. Powell is trying to serve me with a lawsuit and calls me up and says, Jeremy, what's your address? I don't have any duty to tell him that. I don't have a duty to tell him when I'm going to be at work so they can find me to serve me. And there's no duty to either affirmatively provide your address so you can be served or respond to a question about it. Now, then the second bucket is the discussion of the subpoena. And as you also alluded to, Your Honor, Shelter did exactly what it was required to by the subpoena. The subpoena said, answer these questions or provide these documents or object. And Shelter objected and filed a written objection 4 days after the subpoena was issued. It didn't even drag out the timeline more than it needed to. And it filed timely objections with the court. And then, as you alluded to, nothing happened. There's nothing in the record to suggest that there wasn't even a meet and confer on the issue. I would not have been involved in that. I don't know either way, but there's nothing in the record to suggest that. There's no motion to compel, and there's no hearing on a motion to compel. Second, another reason.
And is your argument that that's essential for him to maintain that claim?
Well, yes. My argument on that is he's saying that Shelter had a duty to respond, and Shelter did respond. So does Shelter have a duty to not object to a subpoena when a subpoena says you can object? And then if Shelter does object and you don't file a motion to compel, is it then fair to place the onus on Shelter that the objections must have been somehow wrongful or something like that? If you look at the subpoena, it doesn't even directly ask for the address of Mr. Diaz. Now it asks for declaration pages over a number of years. In my experience, usually addresses are on those declaration pages. But my point is, if we're going to put all the eggs in the basket of your duty was to respond to this, you had a duty to respond to the subpoena, and if you had responded to it, we would have been able to serve you in time, then I don't think we get there when this.
Your argument is you responded.
Yeah, yes, we responded.
Fight is on and he didn't take up the fight.
Yes. Now, finally, Your Honor, and you alluded to this earlier, the other issue with the subpoena bucket is the timing subpoena. So and I'm happy to go through, they're in our brief, and I know you guys are familiar with the records, but happy to go through it and just touch on it just in case there's any questions. So the subpoena, the first lawsuit, Beehive 1, which is the one we're talking about, the case number technically before the court is Beehive 3, but we get into the relation 6208, the relation back statute. So what they need to show they commenced Beehive 1 timely. And so that's really what we're talking about. They filed that on March 30th. That is filed on March 30th, 2023. We say the 90-day, I think correctly say the 90-day deadline to serve Beehive 1 under 6203A1 was June 28th, 2023. Mr. Powell, I don't know if this was in the briefing, maybe I missed it, but mentioned today that he may disagree with that timing, but I don't think it matters if we are off by a day or two on that for purposes of the improper 30-day extension. And here is why. If you look at the Reed v. Miller case that we cite in our brief, what that says is that for the 90-day relation back, the extension needs to be, quote, sought and granted prior to the expiration of the original period provided by 6203A. And so the motion to extend it was sought on June 29th, which we say is one day after the 90-day deadline. And then it was not granted until July 14th. And I don't think there's any question. I'm not the best at math. I have miscounted on occasion, but even if I miscounted somehow in the brief and it was actually July 29th instead of July 28th, June 28th instead of June 29th, it's not that there is no question that the 90 days had expired well before the purported 30-day extension was actually granted on July 14th.
So it's the July 14th, it's granted, and then that's when you filed your objection then?
We did not file an objection. Shelter had separate counsel that filed an objection to this subpoena. The court at the same time granted the 30-day extension, we say was untimely, and then although the subpoena was filed as a business record subpoena, which we also argue was improper because there were no parties on which it could be served, which is a requirement under 6245A. But in any event, the 14 days since the notice was filed had not expired. It was filed on July 14th. On July 7th. But on July 14th, the court both entered the 30-day extension and ordered that the subpoena be issued. The subpoena was actually issued on July 17th. Shelter responds on July 21st.
Okay.
So and the business record subpoena notice was not filed until July 7th. And I think that is also unquestionably after the 90-day deadline.
All of this was argued before the district court.
The 90-day issue on the motion to dismiss. No, the 90-day issue was not challenged on the motion to dismiss. That was raised in our brief, but I would go back to the same Reed versus Miller, right decision, wrong grounds issue.
But the district court ultimately issued the subpoena.
Correct.
Although you contend wrongly.
But you get served with the subpoena and then you object is what happened.
Shelter got
Shelter
served this,
and they file their objection.
yes.
But not based on that,
File
based on the 30 days.
yeah, not based on the time.
Yes, no, Shelter does not object based on the timing that I'm aware. I think there were, I don't have it in front of me. I think there were some of what Mr. Powell alluded to, some of those issues raised. I think there was maybe also an attorney-client privilege issue or something like that raised.
Okay.
The only other thing I want to touch on, Your Honor, unless you have any more questions, is if we then sort of take a step back and do dive more into the equitable estoppel issue and those questions, as we outlined in our brief, it is a very high bar to use equitable estoppel to prevent a statute of limitations defense. And we outlined that there's you need to, it essentially adds an extra element, as we cited in the Dunn v. Dunn case.
But is it being used to prevent a statute of limitations defense? Or is it being used to prevent a service defense?
Well, again, if it's being used to prevent a service defense, that would be something that I am not aware of this court or the Kansas Supreme Court ever recognizing before, because all of the situations in which it has previously been used for the statute of limitations are issues of the substance, where something about the substance of the claim was hidden. For example, I think the one that jumps out to me, I think this is the Robinson v. Shaw, like the doctor left something in during surgery and then didn't saw the x-ray and didn't tell the patient. And so all of these are substantive. So it's as far as our research was able to reveal, this would be the first time that it has been used in a Kansas appellate court to get around service. And I'm not saying
Add a motion to dismiss. To get around service. Yeah, okay.
And I'm not saying it's impossible to come up with the factual circumstances in which that would exist. And maybe in this case, for, how, I don't know how you the problem you're going to continue to, sorry, am I open?
No, okay, go ahead.
Yeah.
The problem you're going to continue to run.
Remember, I'm bad at it. I'm good at it. Okay, go ahead.
The problem you continue to run into is that you would continue to run into if applying it in service cases, is that there's no, where's the duty? When do you have the duty to provide information so you can be served?
Well, that would get figured out. That would get sorted.
Yeah.
Wouldn't get you out of, being served.
Yeah.
This would get sorted.
The duty to provide information so you can be allowed to be.
Yeah.
Yes, and I don't think we come anywhere close to that in this case, where, and on the notice pleading, I appreciate and don't disagree that we have notice pleading in Kansas, but there is a difference between saying, well, I don't have to list out every single element. I think that's different than, you have to include the facts in your petition that support the element. You don't necessarily have to say this fact supports this element, but as Judge Bolton Fleming noted, there were facts that are an absolute necessity for this estoppel defense that were simply not in the petition. But as I mentioned previously, we don't even need to get to the question of allowing discovery to get into that, because there is no duty. And this is a negligence case and was thus barred by the statute of limitations. Otherwise, I'm happy to answer any more questions, but we stand on our brief.
Very much.
Thank you, Your Honor.
We let him go over so you can have 5 minutes instead of 3. How's that?
Thank you.
So about half of that argument was on things that never were addressed to the district court or in the motion to dismiss. It seems like defense counsel enjoys making me look bad. That's his motive. I don't know, or just coming up with whatever arguments he could. But the truth is that this was filed as a breach of an implied covenant of good workmanship claim. That's a 3-year statute. I knew it was 3 years when we filed it within the 3-year period under COVID rules. I didn't use the word negligence in the petition on purpose. I didn't need to. I had a 3-year statute. We just needed to get him served within 90 or 120 days.
Tell me what impact do you believe, or what importance we should put on the fact, if any, the fact that you tried to get this information from Shelter, which is the basis of your equitable estoppel claim. They wouldn't provide it. They object to the subpoena, which they're entitled to do, but then you don't do anything.
Yeah, what I was trying to explain before, maybe I didn't do a very good job, is the doctrine of equitable estoppel, when it bars a statute of limitation defense or service defense, it bars it. So if we would have had a hearing and got the address, we'd have still been beyond the 90 or 120 days by the time that occurred. And we would have been arguing the same thing that we argued in the new suit, is that the doctrine of equitable estoppel allows us to proceed, and they can't use the 3-year statute as a defense in the 90-day rule because they concealed and were silent, or they got their insured's permission not to give out his address.
And that would,
So it's the same result.
in order for that to apply, though, they would have had to have had a duty to do something prior to the subpoena.
Well, the way I see that is, can't find a case that says you have a duty to give an address, but when you're requested to do it and you're silent and another party is detrimentally harmed by your silence, there's consequences to silence.
Okay.
Maybe there's no case that says they have a duty to give me the address, but that by being silent and not cooperating and not acting in good faith, their silence gives rise to consequences for the doctrine of equitable estoppel.
So help me get through this procedural steps. You've got Beehive 1, you're trying to get him served. Shelter's not being forthcoming, and the subpoena is filed in Beehive 1, correct?
Yes.
Okay, so the subpoena is filed, they object, and then Beehive 3 or 2 or whatever is the one that you make the equitable estoppel argument in.
And
You wouldn't have made that in 1 because you didn't have it yet.
yeah, initially what happened is we filed Beehive 2 and the defendants with that equitable estoppel argument
Okay,
in it. But the defendants objected, oh, you can't sue in the name of Beehive because their corporate status got revoked. And so
so there was a different problem on Beehive 2.
procedure one, so the judge said, so I'll just.
We're not dealing with that.
Yeah,
We're not dealing with that.
we're not.
Okay,
So we,
Beehive 3,
yeah,
you make the equitable estoppel claim. I guess my question is, what was your duty to get that resolved in Beehive 1 when you had an opportunity to get the issue resolved? What?
my duty was to use good faith efforts for my client to try to get the defendant located and served. And
And you did,
I-
and you did, and they objected. Don't you have a duty then to get, I mean, we can't assume they were objecting in error. Because they, as he said, they did what they were allowed to do, which was you served them with a subpoena and it said you've either got to provide the documents or tell us why you're not. And they filed a motion telling them why they're not.
a court approved and ordered subpoena, and then they're silent. I think there's
They're
consequences
not silent. They
about the address.
Subpoena.
Yeah.
No, but I mean, they object to the
They-
subpoena. If I'm a business and I get a subpoena, I don't immediately have to turn that information over. I can object and have a hearing on whether I have to. And wouldn't it be your responsibility once they object to make, or maybe it was their responsibility to get a hearing date set to get an order from the court? I mean, what they were doing, I'm assuming, is a motion to quash the subpoena.
Yeah, so that
And
is,
so,
sorry.
so am I way off track here or?
Well, I think the answer to your question or point is that case stayed on the books
Beehive
was
one,
pending during Beehive 2 and 3, and then got dismissed when we got service under Beehive 3. So we didn't, the need for a hearing to get the address from shelter got resolved when the co-defendant provided the address to me right after we filed.
but then you're gonna be using this as equitable estoppel to get you past the statute of limitations problem.
We couldn't get him served in that 90 or 120 days because they were silent,
Okay.
and they may have had the defendant's cooperation. This all
Okay.
comes down to,
It's complicated.
I think it all comes down to what does the petition allege under the Zimmerman case, and do those facts create on their face, state a claim on that theory or any other theory? And
So regardless of what factually happened, as long as you pled it, that's it.
yes, Zimmerman and the Journal broadcast case, and we're in court, and we've got to now do discovery and survive a summary judgment motion. That's what I thought was going to happen, but we never got to that.
Right, I get it. Okay.
Yeah.
Thank you very much.
Thank you, Your Honor.
We appreciate your arguments. We'll take the matter under advisement.